guys.
Okay.
Great. All right, you guys can hear me in the back though, okay, right? Perfect. All right. My name is Chase Eshelman. I'd like to thank Randy for giving me the opportunity today to speak. I'd like to thank Todd for also letting me come and do the presentation. I think someone's let in over there on the side.
Key for that.
As you guys all should know, I'm doing a presentation on what it means to be an expert witness. By a show of hands, who here has served as an expert in a case before? Either consulting, testifying. Okay, so a pretty fair amount of you. Have you guys all been to trial, or is it ended before it got to that stage? Been both? All right. All right. So hopefully what you'll hear today is going to be, something new, something you guys haven't already seen. But for those who haven't been an expert, it's definitely a rewarding opportunity, something you guys should consider. So first, a little bit about me. I'm an associate at Lochner Law Firm. Yes, I am old enough to practice law. I know it might not look it, but I do promise I have a law license hanging over my desk. And no, Todd is not my father. Sometimes people think it's take your son to court day, but he is a good boss. So many of you guys know Todd. Many of you guys do not know me. I've been in the firm for a couple of years now. It'll be coming up on 3 pretty soon here. We are both members of the Maritime Law Association, and our firm specializes in maritime law. Our clients include people like surveyors, people such as yourselves, as well as mariners, captains, contractors, and the like. So, what does it mean to be an expert? Often, expert testimony is crucial to a case. In any situation where you need a certain opinion that relies on any sort of scientific or mechanical knowledge, a layperson cannot give that opinion. That's where experts come in, such as yourselves, such as marine surveyors. And a lot of times, the expert's opinion is almost a smoking gun. A case can come down to a battle of the expert, at which point it's you against another one of your peers, and it's your job to convince the judge or the jury and to explain to them the issues that are often complex and difficult to understand. And often, your job goes beyond just giving testimony. Usually, you'll be required to write a report. These reports can be kind of exhaustive, both in the fact that it's exhausting to write because of how long it can be, and because it needs to include all of your opinions. And even after the report, assuming this doesn't settle, you're going to have to go to trial. Some of you have done so. And trial comes with it its own challenges and its own rigors. Now, the first stage in being an expert is being qualified as an expert. So what does it take? I feel like this is on its own. What does it take to be an expert? So at least in the federal context, Rule 702 sets forth the parameters of what you need to do to be an expert. Under that, an expert witness must be qualified by knowledge, skill, experience, training, or education. There is no precise test as to how much of each you have to have, but there's a combination typically required of some of those amounts. And you can be an expert in one thing, but not another. For example, you all might be experts in marine surveying, but you're not going to be experts for the purposes of accounting. So you'll be admitted and qualified for a limited field. This is a great clip from My Cousin Vinny, where Ms. Vito is admitted as an expert.
Tune-up, oil changes, brake relining, engine rebuild from trannies, rear end.
Okay. But does being an ex-mechanic necessarily qualify you as being expert on tire marks?
No. Thank you. Goodbye.
Sit down and stay there until you're told to leave.
Your Honor, Ms. Vito's expertise is in general automotive knowledge. It is in this area that her testimony will be applicable. Now, if Mr. Trottle wishes to voir dire a witness as to the extent of her expertise in this area, I'm sure he's going to be more than satisfied.
Okay. All right. Now, Ms. Vito, being an expert on general automotive knowledge, can you tell me what would the correct ignition timing be on a 1955 Bel Air Chevrolet with a 327 cubic inch engine and a full barrel carburetor?
Bullshit question.
Does that mean that you can't answer it?
It's a bullshit question. It possible answer.
All right. I think this is clicking by itself, but in any case, Ms. Vito was admitted as an expert. But being admitted, of course, is only half the battle. Not only must you be admitted based on your knowledge, training, experience within your particular field, but your opinions must also always be rendered to a reasonable degree of scientific or engineering certainty or whatever sort of particular field in which you are testifying. Now, that means, as a practical matter, you have to kind of show your work. Your opinions cannot be based on just pure speculation, as you will see later what happens when that comes into play. And beyond just having an opinion that's rendered to a reasonable degree of scientific or engineering certainty, your opinion must also pass typically one of two different standards, which we'll get into. And those standards govern the admissibility of your opinion. So you could still be an expert, but if your opinion doesn't pass one of these standards, then it doesn't come in, and then it's not helpful to the client. So the first standard, this is the older one, it's called the Fry standard. It's less friendly to the cutting edge. Why do I say that? Well, the Fry standard was known as the general acceptance test. And what this means is that an expert testimony is admissible only where the scientific technique or methodology is generally accepted as reliable in the relevant scientific community. So if all of you here cannot agree on that, this testing method is accepted because it hasn't been in place long enough, typically you won't be able to rely on that, which is why it's less, friendly to the cutting edge. Now, under this Fry standard, the judge's role is limited to determining whether or not everyone agrees that this is good. A good test, it's, passes the smell test, so to speak. There's really not much more the judge does other than say everyone can agree that this is good. The second, and this is what is used in federal court, which a lot of times we find ourselves in the context of maritime law, it's known as the Daubert standard. And this is patterned off of the Federal Rule 702, same one as earlier. And under this rule, whether or not your opinion can come in, we look at whether or not a couple of criteria are satisfied. The first is whether or not the techniques or theories that you guys are employing have been tested. Can you test these? The second is whether they've been subject to maybe peer review or publication. Have you written any papers on them? Has other people, come together and said this is okay? Third, whether there's a known error rate, whether there are controlling standards, and whether they have attracted any sort of community attention, or acceptance, but not necessarily a general acceptance. So this test is usually friendlier to cutting edge tests because the judge will actually evaluate the test itself and see whether or not it applies. And of course, the Daubert standard has been kind of explained to also apply to people like you, right? People might not just be scientific folks, it might also be engineering folks, marine surveyors. So why should you care? As I think someone noted earlier, it's a lucrative opportunity. It's a good way to make some extra money. Experts can often charge a pretty penny for their work. You should also care about the standards I just mentioned because depending on where you're at, depends on what the standard is. And these standards are very different. You might have a way to get your opinion in under one standard, but not the other. So for example, Illinois, Minnesota, New Jersey, New York, Pennsylvania, or Washington, some of these are places you guys might find yourselves, particularly maybe New Jersey, maybe New York. Your methodology is looked at under the Fry test, as long as you're in state court, of course, and therefore you might not be able to use any cutting edge techniques. So now you're admitted as an expert, you're qualified, you have the required training, you have the experience, you've been designated by your client. If you're in federal court, oftentimes, unless otherwise agreed, you're going to have to write a report. Now, Rule 26 of the Federal Rules of Civil Procedure says what you have to put in that report, and it's exhaustive. You have to put in a complete statement of all opinions that you're going to express and the basis for those opinions. You also have to talk about the various facts you've considered, the data you've considered, any exhibits you're going to use to summarize or support those opinions. You also have to put in your qualifications, a list of other cases that you testified in. It's exhaustive, and the problem is if it isn't in your report, it's really not coming in at trial. You have to do all of the legwork there. Otherwise, if you don't put it, it's not coming in. And these reports are often crucial. It's not often that you'll win the day just on the report alone, but you can lose the day based on your report if it's not full. Now, another thing to keep in mind, and we'll discuss this a little bit later as well, in some jurisdictions, particularly in state court, a communication with the lawyer and the expert regarding these reports isn't always, sacred. Sometimes those draft reports can get disclosed to the other side if they ask. And what that means is if you have a first draft and that your opinion changes over those two drafts, by the time you're done, it's going to be a very big sticking point for the other side to say your opinion has changed. So, reports, what do they look like? I have three with me, really two actual reports. The first one is a report from ABL, and this is from a litigation that Todd and I are currently involved in. This is a good report. As you'll see, this one was pretty voluminous. The only thing I can really fault it for is the fact that it still has the draft on the report number, but substantively, it's really quite good. So as we look at this report, again, it was very long. So the author put in a table of contents that helps the parties. It also helps, the judge when they're reviewing it potentially as well. You can see that it sets out the scope of what this author is looking to do. And it goes down. Now, substantively, we can start with basically the first page of the report. You'll notice already that we have a lot of those items that are required under the rules. We have what the expert considered. We have a list of his credentials. He also attached a resume. You also have the various documents that he reviewed. And I'll tell you that on the next page of this, which I didn't include, is a whole other page of just documents. So again, it's an exhaustive list. Scrolling further down the report, you can see some more of the substance. Everything is very well organized in paragraphs. You'll note that this report is virtually unmarred by any spelling or grammar mistakes. It's clean to look at, and this thing has got a mind of its own. Goodness gracious. It's clean to look at, and I guess we're moving on.
There must be a timer on there, something.
All right. My hands are tied, apparently. So that was a good report. It's clean, it's succinct, it goes into everything that needs to go into. There's no spelling mistakes. There's really no way to attack it. This is an example of a bad report. Now, not all reports are going to be great stellar reports. Sometimes they're just okay. But when you do a bad report, you really open yourself up to attack later from the opposing side. And if your case really requires expert testimony, it's really going to be detrimental to your case. Now, zooming in here, you can see the assignment. This is another one of the cases that Todd and I have worked on. Hopefully you all in the back can see enough. One of the things you'll note from the beginning is that there are some spelling mistakes. It might be a little hard to see them first. Once you start to notice them, they really pop out. Now, the first kind of error too is that this heading risk has no bearing on what is actually beneath it. But as you get further into the report, you'll start to notice that something is amiss. And if anyone can see it, maybe let me know what you see that's wrong with this, if you read it for a few moments. I'm sorry, what was that?
I don't believe.
Right, well, and not only that, all of this is written as a rebuttal to something else. There is no sort of affirmative opinion other than I disagree with what someone else said, but we don't have what someone else said in here. This is all without context. It's very hard to read, and there is no, affirmative statement by this expert as to what he thinks. Just I disagree with what the other side said. And as you go down, that continues. And as a practical matter, this is sort of the end of the substantive report. And beyond the fact that this report is written really more as a rebuttal, the report also was in a lot of sentence fragments. Nothing was really complete. This is the ugly. This is what happens when you have a bad report. So what I have on the screen is a motion for summary judgment, which is basically a large motion that happens towards the end of the case that tries to more or less win the case before you go to trial. This was filed in that same case as a response, partly to the expert report I just showed you. As you note on the screen, this motion attacks the fact that there was no attempts to offer any affirmative opinions. It reads as a series of random statements, and in many cases, grammatical sentence fragments. Did not contain an exhaustive incorporation of all opinions, because the bulk of the opinion was that additional testing was required. Moreover, there was no opinion about damages, which was critical in the case in that report. So,
And can I ask you a question?
please,
We're trying to read this. Can you just give us a little summary of what the expert was supposed to respond to? Like, here was the case, I mean, I'm trying to read it back here, tell it.
sure.
And
So,
because if the expert got booted out of the case because of poor grammar or poor, random statements.
right.
So as when you ask them for information, just a little bit of background, okay, who made the determination? How was it determined? Did you, as the representative that you would hire as your expert, why didn't you step in and say, hey, look, man, we need to go back here and we need to make some corrections before you send it into the judge?
So we actually did, and so I'll show you that after the slide. If my PowerPoint doesn't let me do that, hopefully it will.
No worries.
But yeah, so the expert's first report, which I believe was submitted close to the deadline, that was there were some issues with that, right? That we had pointed out, and the other side was quick to point out as well.
And just to reiterate, he said close to the deadline.
Yeah,
Don't give us your report at 11:59 PM.
right.
When it's due by midnight.
And to piggyback,
They were working in Australia.
to piggy,
Now, lawyers will let things go and pop up a couple of days before, so.
it happens. Now, I have also been in a situation where the morning a report was due, and the expert had agreed to write this report, and it was all, they said, okay, we can do this. The day it was due in federal court, goodness gracious. It just does what it wants. The day it was due in federal court, the expert called us that morning and said, I can't write it. Just, you know what? I don't know what to do. Not for me.
That's bad on his part.
Thank God we were able to find someone else, one who would do it. Thankfully, it ended up being a better fit anyway for the case. We also got an extension, but that was not the phone call you want to get in the morning from your expert when they just say, you know what? I told you for the last 2 weeks I've been working on it. Now, I don't have anything written and I can't help you. That was not good. So going back here, we have the attack from the opposing counsel. So what do we do when we get this? Well, fortunately, there was a way to salvage it. And the actual salvage will come later in the presentation, but essentially what you do is you supplement the report, right? As long as you have some wiggle room in the deadline, just because you write one report doesn't mean you're limited to that. You don't have to pigeonhole yourself with those opinions. You can oftentimes supplement that report, especially once you depose the other side's expert. You get their supplemental reports, you get their opinions more fleshed out, you can rebut those, you can add to it. So you're not totally locked out. That being said, that is not an excuse to give a bad report on the first go around. And again, I do want to touch on the disclosure of draft reports because I think there's a practical benefit we can all use. So again, generally in federal court, you don't need to worry too much about this. Now, the general rule in federal court is that you have to disclose all information considered by a testifying expert. And that could theoretically include a draft report. But courts have made a carve out saying this does not extend to those draft reports. So even though a party might request all of this information, you don't have to hand it over. In other jurisdictions, however, particularly at state level, those reports are not necessarily immune from disclosure. What that means is if you as an expert send me an email saying, hey, here's my first draft, let me know what you think. And the other side has requested in discovery all of those statements, I might have to hand that over to the other side. At which point, if you change your opinion, when it comes time for your deposition, that will be an exhibit. They will hand that to you and say, why did your opinion change? And then you're going to be on the back foot trying to get around that. So what can you do because of this? One of the ways we get around this is we use a virtual conferencing solution like Zoom or Teams. So if you have something that you want to share, maybe it's something you've already written but haven't sent us in an email, you can pull that up on the screen and we can talk about it without actually producing it to us. That's one of the good ways to get around this issue. Again, it doesn't always apply, but you should be mindful. And if you don't know, err on the side of caution. Use that Zoom. Don't just send something. If you want to discuss with your attorney, do a phone call, not necessarily an email. Now, depositions. A lot of times, after you get your designation in, you're gonna get deposed pretty quickly after that. They want to flesh out your opinion. And for those, who don't know, a deposition is basically like being in court outside of court. It's your on the record sworn testimony, and you'll be asked questions by the opposing counsel. There's not a whole lot that your instructing counsel can do to defend you in that. They can object to form, they can object to a couple other things. But most of those questions, even if they object, you still have to answer. And again, this happens after you provide your report and you've been designated. So that means that really the deposition is going to focus on your report and what you said in that. So this is the time that the opposing counsel is going to first start picking that apart. So let's take a look. This is again from that same case as you were questioning about earlier. So after that expert had written his report, we had this. And for those of you who can't read, I'll read it for you. This is from that same motion earlier as well. Question the opposing counsel. In your opinion, what amount of money would it have taken to restore the vessel to its pre-loss condition following the loss? Answer from the expert. I think I previously testified that my initial estimate was somewhere around $150,000 to $175,000. Question. And when you say estimate, you're not referring to a formal estimate like an invoice? Answer. No, I'm talking about swag. You know what swag is? Question. Enlighten me. Answer. Scientific wild ass guess. That's a bit off the cuff, I apologize, but I did not run numbers down to the penny or, I just the experience. I looked at the boat, I looked at the damage, how much I think it's going to take to fix this boat. Can anyone tell me what the problem is with saying your opinion is a scientific wild ass guess at your deposition?
Do it every day.
Well, it's not rendered by admission to a reasonable degree of scientific certainty. That means no matter how qualified you might be as an expert, that opinion now as to damages is going to be hard to get in. Now, you might try and explain this away, but you already called it a wild ass guess.
But can you not say what your methodology is to say that you've given this scientific?
You absolutely should.
Some prior experience, or but you have to define what you're saying wild ass guess is.
Absolutely, right? You need to
It's
tell.
admissible then. I've used that in front of the judge.
We use swag, right? It's got the word scientific in it, so you can argue that it's okay. And at the end of the day, right, when someone says to a reasonable degree of scientific certainty, that doesn't mean, where is this thing going? That doesn't mean that you have to be positive, right? All it is it's a estimate based on your training, your knowledge. You show your work, you show the way you got there, and typically it comes in. This just makes it an easy attack. This is a buzzword for opposing counsel to use trying to exclude your opinion. So what happened after this? This kind of gets back to your question earlier, sir, about what we did and what can be done. So after the swag comment, the expert had to put in a supplemental report, basically and very directly, going to the next slide, explaining what the swag was. And here you see he gives a detailed breakdown, but that didn't stop the other side from still attacking it. If you can minimize the other side's attacks, as best as possible, great. If you want to use swag on the phone with your attorney, that's okay. But in a deposition, reasonable degree of scientific certainty. Now, after the deposition, typically, if things progress, you'll have trial. And a trial is really where we almost go back to the beginning, right, with Ms. Vito. Even if you've been designated as an expert, you've written your report, you've been deposed, you still have to be admitted to trial as an expert. That means you have to be qualified. You have to discuss your training and your experience. The judge has to accept you as an expert. Then you have to give your opinions if they haven't already been excluded by a prior motion in limine. And those have to pass the test as well. So this is a really good example. This is a case Todd worked on a number of years ago that's still, believe it or not, ongoing. This is 2016. And what I'm going to show you is the opposing counsel's attempt to get his expert admitted. So the first question he asks is, what was your highest level of education you obtained? Remember, education is one of those factors. His answer, I think the School of Hard Knocks. Question, you have a high school diploma? Answer, somewhere. Remember, to be an expert, you have to have a certain level of education, skill, training, experience. You don't need to have all of them, right? The law doesn't require that you have more than a high school diploma to be an expert, but this certainly doesn't help. Moving down, when did you graduate from high school? I can't remember off the top of my head. Again, you don't need to have all of the answers, but you should come prepared for trial or a deposition. At both, you're going to be asked about your credentials. You're going to be asked about your skills and your experience. You need to be ready to provide an answer to those questions. These are softball questions from his own attorney that he couldn't ask. When asked again if he did any teaching or lecturing in the field, the answer was no, I don't know what you mean by teaching, but I do get asked for my opinion quite often. Well, folks, everyone has an opinion, but having an opinion does not make you qualified to be an expert. You can't give that opinion unless you are qualified. This thing's speeding right along, but you can see what the court has said at the end. He's never going to qualify as an expert. He might have the experience, but his work experiences doesn't meet the requirements. Vague on boats he's worked on. One thing he's done is testified over and over again. He's given 30 years of service doing various jobs, one of which was a bow thruster, right? This is detrimental to the other side's case. They needed an expert in this case. Their expert was taken out from the beginning. So, what does all this mean putting it together? Well, first, those who have the required experience, training, skill, or education can be qualified as an expert. Presumably, everyone in this room has that and could serve as an expert witness. But just because you can be an expert doesn't mean that your opinions already come in. They must satisfy the relevant standards. They must be rendered to a reasonable degree of scientific and engineering certainty. Now, most experts will be called upon to write a report. Some state cases or some states don't require that. Maryland State Court, you don't really need to write a report. Sometimes you do it, sometimes you don't. Federal court, oftentimes you do. There's the exhaustive list. You have to make sure you follow that. Your instructing counsel should help guide you with what you need to include. But you should also try and be self-sufficient. If you're a good expert, you will make sure that you hit those marks every time. Also, you find yourself being deposed, kindly refrain from saying that your opinion is a swag. Todd and I use that term all the time amongst each other. Don't use it at your deposition. It will come back at trial. If you paid attention to the motion, a lot of times when the opposing attorney was talking about the swag, he took off the S. He just called it a wild ass guess. Yes, it was scientific, mentioned in the deposition, but it opens yourself up to easy attack. Try and avoid that. This should have been a bit longer, but it seems like the maybe the time constraints are pushing me towards the finish line sooner. Any questions? I could explain the court case a bit more if you'd like, sir, in the back. Basically, that case involved damage to a vessel, potentially from storm or rainwater. The other side had sent in their own experts. They wrote reports to which our expert then responded. And instead of doing his own, here's what I think, he basically responded to each paragraph of the other side's report. So when you have it next to one another, it makes a good bit of sense, but these reports should be able to be read by themselves. When you're writing a report, don't make it so that it requires the other sides to make sense. It needs to just be its own report. And after which the court made some rulings. Ultimately, we got him back in, but it was an uphill fight and one that we wouldn't have had to have had the report been more fleshed out from the beginning and had swag not been dropped at the deposition. With that, any other questions?
You've got to tell us who that surveyor was.
No way
Nope.
in hell.
No, I was hoping he wouldn't be here. I had a second presentation with those removed and something else just in case, but yeah, no, he's not.
It's Lloyd.
It's Lloyd.
And it could be one of those under the hidden glass up there too.
It's not, I checked.
Yeah, we had to
Although
look.
we have worked with plenty of people that are on the Zoom call, I checked.
Yeah.
Any other questions?
Hey, Attorney Harry, question for you.
Go for it.
What's the oldest profession?
Oldest profession? Prostitution.
No, it's not.
Lawyering. No? What is it? Tool making. Okay.
What the second oldest profession is?
I'll let you tell me.
Dentist.
Dentist.
Pull the teeth out of your head when you stop smiling.
I like it. I like it. All right. Well, thank you all, guys. That concludes our presentation. And since it's being recorded, there's our information. If you have any questions, you guys can certainly feel free to reach out. Thank you all.
very much, Chase.
Thank you.
I did put a question on the chat.
He's along like that.
Dylan had a question.
That was a first for me.
Dylan has a question?
Oh, Dylan.
I put one on the chat.
Okay.
Just.
Chat GPT to assist in writing reports. You know what? Despite my age, I've never even opened Chat GPT, which is kind of surprising even to me. I will tell you that in the sort of law news, there have already been attorneys who have been burned. So one of the problems with Chat GPT is it can write some things that do sound pretty good. It can also be a really convincing liar. And if you're not careful, it will write citations that don't exist. It'll be in the proper format. It'll say what it wants to say, but those cases, if you look them up, they're not real. So if you do use Chat GPT, and maybe if you're not a good writer, you might want to give it a try and see if it maybe polishes up your writing a bit more. But you have to be extra careful to make sure that what you're telling the court isn't a complete lie. As attorneys, you can be sanctioned for that. You have a duty to sign your pleading and say that, yeah, this is the facts of the law are accurate. You give them a fake case because of Chat GPT, the judge will not accept Chat GPT wrote this for me as your excuse as to why you shouldn't be disciplined. So I definitely would stay away from Chat GPT.
Chase, I have one follow-up.
Yeah.
You ever had a case where your expert told you one thing and you convinced that's how it went down, and all of a sudden you had another expert says it's completely opposite?
I have actually.
Because that's very hard for the ego of a lawyer to change.
I have. So I'll be delicate here. Basically, we had a case where we had one expert saying it was, X reason why, this particular part failed. And we were like, well, let's get a second opinion too, just to see what else we could maybe see. And we got another expert, whom we know, and he basically said, with diagrams galore, here's exactly why this component failed. And our expert, the first one, if we went with his opinion, it would be, yeah, it's probably a covered loss under the policy. The second one, no way in hell. So we had to tiptoe around the issues pretty lightly, but we kind of had an idea then as to at least maybe what we'd be up against too. But at the stage in that litigation, there really wasn't an opposing expert who had the opinion as our second expert, so to speak. Their opinion was pretty demonstrably wrong. So it's pretty comfortable from where we were in a litigation posture. But I've certainly had the second opinion come back and say, no, not what you guys think. It's what no one really realizes yet. And it's been interesting. It's but you got to be quick on your feet, right? You have to be able to adapt when you get that really adverse second opinion. And you got to realize, okay, well, if someone ever gets wise to this, the case is really done for. And the other side could realize at any point that, hey, you know what, we've been wrong too. It's actually this reason. And that typically kind of fosters a settlement posture, to be honest, as far as, well, let's get this case kind of wrapped up. That way we don't go to trial and they get wise to it on the witness stand.
Not to be crass, but have you ever heard of treat them like a mushroom?
Exactly.
Yeah, dark and shit. So expert one was kept in the dark and fed shit.
Just go along with what you think, and we can get a report that still lines up, and that's what that expert's opinion really is. But we'll keep the other one far away from the case as possible. Yep. Good questions. Any other questions? Anything else in the chat? I don't think so. All right.
So much.
Thank you all.
Brilliant. Thank you. Yeah, yeah. I'll sort that out. All right.
Much appreciated.
Nice to see you. Thanks.
Thanks. Thank you, Randy.